Temporary orders are the court will identify an issue during a case that has to be addressed, and usually pretty early on will issue an order so that that situation is managed and that you can rely upon court's enforcement of said order during the case. Probably the most common one that people will think about is temporary custody, temporary parenting time, temporary support. Those are the most common ones that you'll have in both divorce cases and custody cases. You've split up now. Maybe one spouse is or one partner is the higher earner. The other one is either a housewife, house husband, or doesn't work that much, or has a low paying job, and they need a support order. Okay, well, can't allow the children to go without, so we'll issue a support order fairly early on in a case, at least a child support order, so that there is some money flowing from the obligor to the obligee. The restraining order prevents both parties from either disposing of property, making large financial transactions, purchasing new property, making large new investments. The point being, let's freeze what's going on here so that we can identify and divide equitably or equally as the law provides. Sometimes, unfortunately, too often, you will have domestic violence in a family. And the domestic violence civil protection order, when you seek one of those out, you will get an ex parte order when you first go. An ex parte order means without one party present. So just one party going to the court and making testimony so that the court can issue a ruling. In the context of domestic violence, that's a special scenario because normally you are not allowed to engage in ex parte communications with the court. This is an exception. One party goes to court, says, I need an emergency protection order. And if they've got grounds, they will get one. That's a temporary order because 10 days later in the domestic violence civil protection order law, you will have a trial on that issue because it is such a large uh, restraint upon one spouse or one partner in a relationship, and it is without their input. The normal rule is if you go to court, both parties go to court. Both parties make their arguments, court issues a rule. So if one party can go on their own, that is super special, and therefore we are going to have the trial very, very quickly. Uh, in the context of both domestic relations and in custody court, you can also have an emergency custody order. Let's say uh, one spouse or a partner has placed the children in imminent risk of harm in some way. Either there is drug use in the house that is, to a great extent, or there's criminal activity in the house, or let's say there's, firearms without a firearms safe, or there is a violent perpetrator in the home, or some other condition in the home that would present a risk to the children. Let's say black mold in the basement that is unaddressed. If you had something like that and you're the out of possession parent, you can file a motion for emergency custody. And if you present an imminent risk of harm, the court will grant you custody of the children on a temporary basis. That's not for the rest of their lives. It is only until the case is over. And that's just kind of scratching the surface. The courts are empowered within the rules. And if you are in domestic relations court, that is Ohio Civil Rule 75N. If you are in juvenile court, that is Juvenile Rule 13. The courts in juvenile court can issue whatever temporary order they think is in the best interest of the minor children in their case. In domestic relations, it's split up to a few particular categories, but it's still a pretty broad power to issue orders that they think are going to facilitate peace in the case. Exclusive use of the marital residence is a temporary order. So if the most common scenario is somebody has left the marital home and they're gone. They've moved on, they've got an apartment now, maybe they're living with a new boyfriend or girlfriend, whatever, and they've been out 30 days voluntarily. Then the person who remains in the marital home says, I just want him to not show up again. Thank you very much. And I'd like to change the locks just for safety. And the court will grant that if the leaving spouse has been gone for 30 days or more. There are scenarios where you can argue that I should have exclusive use of the marital residence because the continued presence of the other spouse is too emotionally damaging. But that's a hard argument to make. It has to be significant in order for that to be granted on that basis. Generally speaking, the marital home is available to both spouses throughout the divorce case, absent such an order. I should make a special note about support orders. In the context of child support and spousal support, if the final order of child support or spousal support is greater or less than the temporary order that was issued during the case, you have retroactivity, which means if your temporary child support order, let's say, was $1,000 a month, and you get to the end of the case and you run the calculation, and now it's $800 a month. You owe back $200 a month times number of months, all the way back to the beginning of the case. And that goes the other way too. If it was $1,000 and now our calc says $1,200 a month, then he owes you, or whoever's paying owes the other one, $200 a month times number of months to the end of the case. It is very common to settle that issue out so that it doesn't actually show up. But if you were to try your divorce case, or if you were to try your child support or spousal support issues, and you get a different number than your temporary order, the court can and usually does retroactive that number all the way back to when the temporary order was issued in the first place. It is very important, in my opinion, especially as it relates to parenting time, to get a reasonable parenting order early in the case. There is a certain amount of inertia, shall we say, in courts. Once they have something in place that they think is working, they're reticent to change it. And so, if you are pushing for a 50-50 parenting schedule, or if you are pushing for, more than you think you can get on temporary orders, you really should go for as much as you can get at temporary orders. Because if you cave in to a supervised order, or if you cave into a minimal parenting order, you're going to be pulling teeth to get to the 50-50 by the end of the case. So it is important to set the scene, as it were, in early in your custody case, and to try to get reasonably fair and expansive parenting orders, especially if you're the out of possession parent early on in the case. There's so many, and I'm only talking about the context of domestic relations and child support. If you get into other types of cases, there are many, many other types of temporary orders that you can have. The most important thing to know is that they are not forever. They're not appealable, and they all go away at the end of the case. If you're thinking about starting a custody case or your divorce case, especially if you think temporary orders are necessary and you'd like to have your questions answered, feel free to give us a call at MP Weiss Law. My name is Eric Terry.